is for Florida Department of Children and Families. Helen may proceed.
May it please the court. My name is Megan Wall, and I'm a legal aid attorney, counsel for the appellant William Farris. I'd like to reserve 2 minutes for rebuttal.
I'll try to remind you.
We are here before this court today asking that William Farris's med waiver benefits be reinstated. The standard of review is de novo. William Farris has at all times since the year 2000 been med waiver eligible. He continues to be med waiver eligible today. Nothing in his income, abilities, or circumstances has changed that eligibility. William Farris.
I think that's the ultimate conclusion you're reaching, right? In other words, the state has determined after your client unsuccessfully applied for Social Security disability that that second prong of the test was exceeded, and the income established, I think it's 3 times the SSI level, as I recall the exact wordage, that your client, who made about $1,200 a month, exceeds that income level. And under a strict literal reading of that rule, he does, right?
He does exceed the Social Security disability income rule.
So your argument is, and it, I think it was aptly put in your brief, that we must read all 3 prongs together and disregard the state's own interpretation of that second prong and say that, well, state, this is de novo review. You made an error because that financial component of the rule cannot make any sense because you also have the higher financial component in the third prong, right?
Correct. Said another way, the med waiver program, completely separate from the Social Security program, is an exception to the rule. It's an exception to the Social Security income rule.
But that's not specifically stated in the rule, right?
It is specifically stated in that the rule for med waiver eligibility says that it shall be determined on non-financial eligibility. In other words, they're going to look to the Social Security medical disability criteria.
But then it cross-references the rule with the income, financial. And I recognize your argument that we have to read this in context. But I'm asking you to concede or consider conceding that the state had a legitimate basis for saying, well, the second prong says $880 a month, you're $1,200. We're bound by this second prong, right?
I'll concede that that is their misunderstanding of the way that these 2 statutes interrelate. That it's a failure to understand an exception to a rule.
Or a flaw to the statute.
Or a flaw to the clarity of the statute.
Right.
I believe that the statute is clear upon a statutory interpretation reading that 2 things that seem to contradict should be read in a way that makes them both make sense.
But we'll have to acknowledge, to rule in your favor in reverse, that the statute is flawed, essentially.
The statute certainly is not a picture of clarity.
And we have to say we're going to reverse the agency's own interpretation of its own laws, which is entitled to some deference, I might add, and say we're going to substitute our interpretation and say, no, you have to read all 3 prongs in context.
Under the general rules of statutory interpretation, and that otherwise it doesn't make sense, and that, yes, you have to note that this is an exception to that larger, more general rule. In the same way, Your Honor, there is a hearsay rule. Hearsay is not admissible in court. We all understand that. And then there is an excited utterance rule. This is the case where Mr. William Farris is the excited utterance. So to say later, it's been admissible in the testimony because it's an excited utterance, but then later someone looks at the record and says, but an excited utterance is hearsay, and therefore inadmissible. And you say, yes, it's inadmissible hearsay, but it's admissible because it's an exception, if I can use that analogy. William Farris, this is very important to him because he is a mentally retarded 44-year-old man with an IQ of 44. He will never get better. He will never have a better IQ than that. He will never be less disabled than that. He lived with his parents until he was 35 years old. And his parents, who are somewhat elderly, decided at a certain point they had to do something because they wouldn't always be there.
Counsel, and with all due respect, I certainly appreciate the background here, and it certainly is tragic, but isn't our role limited to looking at this statute and making a determination of whether the agency's interpretation is flawed, not whether the better policy might be to rule in your client's favor?
Absolutely, Your Honor, and forgive me if the history was.
No, that's okay. I just want to clarify that.
Okay.
And feel free to elaborate on that if you wish, but.
Well, just for the point of sometimes the example in the case makes the point of who this applies to and what the services are and why it was created as an exception. Why is there this exception of med waiver? Who does it apply to? And who it applies to are people with developmental disabilities. And for those reasons, they would otherwise be institutionalized if they couldn't stay with their parents. They would otherwise be living off Social Security disability or the public funds if they weren't given support services to go out and make their own living, to be productive members of society, to pay taxes, to earn income, to otherwise be in a supported living environment, which are called group homes. They don't live completely on their own in apartments. They're not able to do that. But in the group home setting, with those support services, it's essentially, as they say, a hand up instead of a hand out. They are able to live productive, meaningful lives, go to work, come home. With those services, they have lives, of rich meaning. And that's why the med waiver program was created, so that people could have those lives and not be otherwise in institutions or in their parents' bedrooms until their parents passed away. The confusion comes that the med waiver exception allows people, as you saw in the briefs, to go up to $1,800 plus a month. The Social Security disability allows you $800 plus a month. There's $1,000 difference here. If at all times the Social Security rule applied to this, what I'm calling the exception, the med waiver category, then it would make no sense that you could ever go up past the $800 plus. Because by definition, suddenly after you made $800 or $900 a month, they'd say, you're categorically no longer disabled anymore. Therefore, you're not med waiver eligible, therefore you can never try to get to the $1,800. So the exception is written right into the Florida Administrative Code that you should consider the non-financial disabilities. Are they disabled in the sense that we use that word? Are they medically disabled? Do they meet or equal a listing on the grids?
And I assume your opposing counsel is going to concede that your client's disabled. That's not at issue.
Not at issue.
Every other qualification is not at issue. Your client was strictly disqualified on the basis of income, right?
That's right. And how did that disqualification occur? In the year 2000, he applies for a med waiver, which he can do on his own, separate and apart from Social Security office. He's eligible, and they tell him because you have a 44 IQ, you're obviously disabled, never make more than $1,800 a month. Those are our rules, stick within our rules, and he has always stuck within those rules. What has changed?
He applied for Social Security disability and was denied because he made more than $880.
Correct. His med waiver eligibility, however, never changed. He was eligible before, he is eligible now. Nothing about his life circumstances, income, has ever made him not med waiver eligible. A confusion occurs because Social Security uses the wording, you make more than $880, you're not disabled. And they're saying, if you're not disabled, you don't get med waiver. But the two statutes read side by side doesn't mean you're not medically disabled. It means there's a different income guideline. I mean, it should be noticed there are income guidelines that are different for all kinds of Social Security disabilities.
In fact, for Social Security disability, the intent obviously is, if I'm not mistaken, those people who are vastly under that income level and cannot work. Is that not correct?
That's correct. And therefore, they deserve a check from the Social Security Administration or from SSI. They deserve to be on the public dole because they're unable to work or fend for themselves. Right. William Farris does not want Social Security disability, withdrew that application, doesn't want that to confuse his issue. He is a productive member of society, working, paying his own way. All he needs are the support services so that he's on a level playing field. He cannot do all of this without, the group home and some supported living. But with that, he can go on and live the rest of his life as long as he has this med waiver. The statutory construction arguments, I think, are the most crucial ones in this case for the reasons that you pointed out. How do you take two things that have obviously confused the department? How do you take things that look like a seeming contradiction and make them make sense side by side? And obviously this court knows those rules better than anyone, but if I may, in the case that they so articulately and eloquently stated in, from my brief, it was on reply brief page 9, was Palm Beach County Canvassing Board versus Catherine Harris. And in that case, the Supreme Court said, where two statutory provisions are in conflict, the specific statute controls over the more general statute. Just like in this case, the med waiver is the more specific, controls over the more general Social Security rule.
Now, that wasn't the case reversed in Washington, right? Not on that basis.
Not on these bases. These statutory rules of construction are still good enough. Where two laws are in conflict, courts should adopt an interpretation that harmonizes the laws. For the legislature is presumed to have intended both laws to operate coexistently and to the fullest extent possible. Related statutory provisions will not be construed in such a way that it renders meaningless or absurd the other statutory provision. And that is the case here with the department's interpretation. It renders meaningless or absurd a med waiver statute that says as long as you're medically disabled, you can make $1,800 or more a month. That's what it says, and then you have to follow those rules. It should be noted, too, that you do not need to apply for Social Security to get med waiver. You do not need to apply for med waiver to get Social Security. They are, in fact, two completely different and distinct programs with completely different and distinct rules. The overlap is that the common denominator of both is that you must be medically disabled. And in fact, for waiver, you must have a developmental disability for the waiver that William Farris is in. Any amount of physical disability will not allow you to get into that waiver program for the reasons that it provides support services to the developmentally delayed. It's confusing to the department. I know it will not be confusing to this court. I would appreciate if there are any further questions. I will be here to answer them.
We appreciate the confidence. Thank you.
Thank you, Your Honor.
May it please the Court. My name is Roger Williams. I'm an attorney for the Department of Children and Families, District 4 in Jacksonville, Florida. The issue raised in this appeal is whether or not the petitioner, Mr. Farris, is eligible for the med waiver program based on the Florida Administrative Code 65A-1.711, which states that he must be an individual who's 65 years or older, 18 years to 64 years of age, disabled in accordance with the SSI disability criteria. The SSI disability criteria outlines that he must set forth in section 435.540 and 435.541, which goes to the issue of substantial gainful activity to determine whether or not he meets the SSI criteria. In this case, Mr. Farris' income level was $1,200 a month, which he was earning at the, I believe it was the River Club, if I'm
How about
correct.
the part of the rule, though? How do you harmonize the part of the rule that says for ISP, gross income cannot exceed 300% of the SSI federal benefit?
You know, that goes to the earning capacity, not necessarily there are other individuals who may receive other kinds of income. They may receive other disability income. They may receive pensions. Those incomes would not be counted. It is the earned portion, as in this case, that would be counted against the individual. The $1,200 is the sole income, I believe, that Mr. Farris, and all of that income was earned income. If there was another basis for financial earnings, again, either through, say, AFDC or he had received income.
So if I understand your argument correctly, counsel, then if his income was, say, $800 a month, not $880, and he received $400 a month, either in AFDC or some other assistance program, he gets to remain in this program, but because he's working in gainful employment and not receiving government assistance, he's disqualified.
Which is the understanding of this program. Just because an individual is disabled doesn't necessarily mean that they qualify under the SSI criteria. You may have a person who is disabled and is able to work in his home, say computer programming, and he may make more than I'm making as a government attorney. That person would not qualify for the Med-Waiver program. The first prong, as was being argued earlier, is that you have to look at whether or not he meets the substantial gainful activity. And in this case, and we must use the SSI criteria as outlined in statute 435, 540, and 541. Under that criteria, he does not meet the definition of disability. And because he is earning
because of his income.
Solely because of his income.
Because you don't dispute his IQ is in the 40 to 60 range.
I don't dispute that as outlined, as accepted by the hearing officer. There's some other questions in the record, but I don't think really that that's an
For our
issue.
purposes, we're limited to that determination, fairly severe mental retardation, right? Just mentally disabled, we'll call it.
Mentally disabled, but apparently he also has some very good adaptive skills, because prior to his application for these benefits in 2000, it says that he's been working at this particular facility since 1981. So it's obvious that this gentleman has the ability to do to take care of himself over and above the 44 determination in his IQ, because in order to look at the issue of the disability, you look not only at the numbered scale, but you also look at what is called an adaptive skills. And this gentleman definitely has the adaptive skills as shown by his work activities, and his work activities then goes to the issue of his substantial gainful activity, which he has been earning at the River Club, earning over $1,200 a month.
So the agency erroneously gave him the Med-Waiver benefit for several years then, right?
Well, it was not outlined in the record why from 2000 to 2004 he was receiving the Med-Waiver benefits. But the rule also requires that an individual, when they're receiving Medicaid, you have to do either an annual evaluation if there's a change in circumstances. So regardless of whether or not he had gone in during that break in employment for redetermination, and the SSA agency came down on the point that he was over and above, there was the possibility that maybe next year or some other time that his eligibility would have been redetermined. And in his eligibility, you had to come to the fact that he had to have a disability determination according to SSI. And the disability determination under SSI goes to his substantial gainful activity, which based on his income was $1,200 over and above the $800 that was outlined in the law.
And our decision really then, in your view, I assume, then turns on that specific point that third prong that refers to an income allowance of $1,700 a month, as I recall, or $1,900, I think $1,709, then the difference between the $880 or the $800 plus and the $1,700 can only be unearned income.
Yes, Your Honor. Because if it is earned income, then it would put him outside of.
And do you think that's because the person who has the earned income that, say, goes to $1,200 a month, like Mr. Farris, that shows that he's potentially not disabled?
Well, it shows that he's able, under the Social Security criteria, that he's able to function. It meets the exact same purpose as the waiver. I'm sure a person who may be considered disabled but is able to function and work would be proud to say, I'm able to function and I'm able to work. I don't want you necessarily giving me a particular label. I'm able to go to work. I'm able to go on my job. There wasn't a question raised that Mr. Farris, even though he was being limited to maybe 30 hours, that he could not have gone to 40 or 50 or 60 hours where he could have earned even more income. That was not an issue, which again would have been counted against his disability evaluation. So I would argue, Your Honors, that there was not a misunderstanding in the interpretation of the statute, that the hearing officer read the statute appropriately. The agency accepted, as it had to, the SSA determination that this individual, because of his income of $1,200, was over and above the...
Well, it didn't have to accept the conclusion of law, right? That's a conclusion of law by the hearing officer that your agency could have rejected.
Yes, Your Honor, they could have, but under the circumstances, they did accept that that determination by the hearing officer that the SSI, that prong of the statute and the rule was met by the agency, and this individual's earnings placed him over and above the SSI criteria for disability, and so we could not consider him disabled based on his income, and we would ask that the court...
And the bottom line is that you say there's no conflict because earned income and gross income are two separate things.
Earned income and income, which is, again, I use the term, again, such as the Social Security or, say, AFDC or some other means-tested funds would not be counted against this individual. They're two very different things. Thank you.
I find it very interesting that the first time I have ever heard the earned income versus unearned income theory is today. It is not in the department's briefs. It is not in the law. It is not.
I just read through their brief because I was interested in that. They do mention the term earned income once, but they really don't make the argument they're making here today. But I'm going to give you an opportunity to respond to that.
And nor does the Florida Administrative Code make any kind of distinction.
Okay, but the language in the 300% says gross income, which seems to indicate that it might be other than just earned income. What's wrong with their interpretation saying if you have an earned income above a certain amount, you're not disabled for Social Security?
Well, the problem would be that the reason why someone can make earned income above 300% is because of the support services they've been given through the Med Waiver Program. That, again, it's a circular argument. How can a person who's an adult retarded person with a 44 IQ make that kind of income? It's because essentially it's a sheltered environment with support services given to him and making sure he's okay to get to work and back every day, helping him get there, helping him with all the coping skills it takes to do that. And that without that, there's not going to be that earned income capacity. And also, if it was an earned versus an unearned income capacity, it should say that in the Med Waiver regulations. It should say that in the Social Security statutes. It should say that everywhere. It should say that somewhere.
It doesn't say that. In other words,
it says not
your
at all.
argument is it's somewhat flawed in that it has the $1,700 a month, the $800 plus a month. One may refer to gross income, but other than that, there's no specific articulation by the legislature or the administrative code what those two differences are.
There is no articulation whatsoever. And it, not to be confusing, but hopefully this is for clarity, the Social Security program has different income levels for various other programs. They have a blind disability level with an earned income capacity of much higher, or an SGA, substantial gainful activity of higher. They have a 1619B program that if you're grandfathered into, you can make unlimited funds. There are different incomes.
Let me ask you a question, counsel. If the department's interpretation is reasonable regarding earned versus unearned, aside from any preservation concern, aren't we bound to defer to the agency's interpretation of the statutes it executes?
If the statutes referred to earned versus unearned, then
if his interpretation is reasonable and your interpretation is reasonable, and it's a somewhat flawed statute, somewhat with contradictory requirements, in that situation, does the state prevail because it's an agency interpreting its own statutes?
The state is giving great deference to interpret its own statutes, but in this instance, we believe that's a completely unreasonable interpretation. Thank you.
Thank you. Being no further cases in front of the court will stand in recess.